have any bill introductions from any committee members? Seeing none from committee members, do we have any from those in the committee meeting room? I think I saw a hand. Please come forward, introduce yourself, and welcome to committee.
Oh, there we go. Now Mr. Microphone works. Okay. So these are all pieces of legislation that have been previously filed. They were already filed in, I think, 18 or 19 as committee bills from this committee. They're all concepts or legislation that's been enacted in other jurisdictions. We're not reinventing the wheel. These are all proven to reduce recidivism and to help keep people safer. Two bills were Senate Bill 85 and 86 in 2019. They're what's called staggered sentencing. Essentially, when we have like a wobbler felony, like a third offense DUI or a third offense domestic violence, they end up serving their time in the county jail, and they have mandatory minimum 90 days to serve. All we've got when it comes to probation is the stick. You know, do what I say or I'll revoke your probation. And what staggered sentencing does is it puts a carrot into the process too to help enhance rehabilitation. It gives them the opportunity that if they comply with probation, they have to serve the initial 30-day period, then halfway through the probation, there's an informal review. If the probation officer says, Judge, he's on track, the judge says, okay, we can stay the next 30-day period. And then if they complete the probation on time, on track with everything, the judge can waive the other 30 days. And so we end up saving money for the counties because they don't have to pay for so much jail time. We also save money for them that they can use for counseling and treatment rather than house arrest. There's lots of benefits to it. It reduced recidivism in Minnesota on DUIs by about 50% in a 5-year double-blind study. So I think the same principles would apply in the domestic violence cases too, because the biggest problem we've got is getting them to go to batter's intervention. The other three bills are on domestic violence issues. One is basically what's called a threat assessment, and it's a threat assessment for the benefit of the victim and for the court so that they know when there's a real serious problem out there. It's simple, it takes about 2 minutes. It's like 10 questions. The victim answers at the scene. And then, you know, the judge will have more information for making bond condition decisions. And then also often the victims seldom understand how much danger they're really in. The next one is what's called primary aggressor language. It's been adopted in many states, and basically it helps brings clarity to law enforcement when they come to a circumstance where two people have got injuries. It helps them sort out who's the primary aggressor with a number of statutory factors. And then the final one enhances the penalties for violation of restraining orders, such as for protection from stalking and protection from abuse restraining orders. All too often we've had one, I think prosecutors generally don't pay as much attention to them as they could because the first offense is a misdemeanor. And then if they have an order and they violate it, and nothing happens, what does that do to the order in the courts? It makes our jobs much more difficult. It puts the victims at much greater risk. And hopefully they'll get the message before we have to get to that second or third one. It's a mild step up. On a first, I think on the current law, the second offense is a Class A misdemeanor, and the third one's a felony. This one makes the second one a low-level felony, and the third one a higher level, like a SL7. And then the third one jumps to an SL4. You know, I mean, it's like a third to a half of our homicides. But those are the 5 bills. They've all been filed before. The RSs are all done. And there may be some little modifications. I just trust Jason on all this. So, you know, I have for 20 years. So we just keep doing it. You know.
Thank you, Judge. Do we have RS numbers for any of those 5 bills? Yes, if we could read the RS numbers, that would be helpful for our tracking purposes.
Oh, absolutely.
Do you have that, Mr. Thompson?
And I know you sent it to your committee assistant. Thank you very much.
Very good. Thank you. Appreciate it, Judge.
Thank you, Madam Chair. Jason Thompson, Revisor of Statutes Office. So in order here, the first domestic violence staggered sentencing is 22 RS 2719. Number 2, DUI staggered sentencing is RS 2720. Number 3, threat assessment is RS 2723. Number 4, primary aggressor, is RS 2725. And number 5, violation of protective orders, is RS 2722.
Thank you very much. Are there any other requests for bill introductions? Those 5 bills will be deemed introduced. Any other requests? Seeing none then, we will turn to the first order, actually the second order of business on our agenda then would be a presentation on the 2021 recommendations of the Kansas Criminal Justice Reform Commission. And we will be hearing from Mark Bennett, District Attorney, 18th Judicial District, and Chair of the Kansas Criminal Justice Reform Commission. So please introduce yourself and welcome to committee.
Madam Chair, I don't believe he's online yet, so we might want to go with Scott Schultz first.
Right, I was going to say, well, then we will wait for Mark Bennett to get connected online, and we will hear a presentation on the Kansas Sentencing Commission Annual Report, Prison Projections and Policy Recommendations, and hearing from Scott Schultz, Executive Director. Please introduce yourself and welcome back to committee.
Madam Chair, thank you. Scott Schultz is Executive Director for the Kansas Sentencing Commission. I guess we're going to save the first for last. Let me see whether we can get... All right. Madam Chair, apologize for that. We're going to start in here, and I do have a few remarks to make, and I appreciate the opportunity again on behalf of the 17-member commission to talk with you today. As most of you know, the commission is the State Statistical Analysis Center for Criminal Justice in the state. We have the ability to gather data from not only our sources, but also DOC, KBI, and any other information or data that we deem necessary to carry out our duties. We do have several of those, but today I'm going to go over just 4 different things for you. We're going to talk about just a little bit of the history. Most of you obviously are veterans here and have heard probably some of this presentation before as far as history, so I'm not going to touch on it too much. But I would like to step on the legislative impacts that you will be receiving on a regular basis for the criminal justice bills and how the Sentencing Commission's impacts can help you in making your policy determinations. We'll also talk about the annual report that we put out, and hopefully that will give you a little idea of some of the trends that are going on. With COVID, of course, the last couple of years, that's kind of basically pushed what the norms are out the windows, even in a statistical standpoint for our criminal justice folks. And then finally, every summer, we do prison population projections for the Department of Corrections, and that is also delivered to the public regarding what those 10-year projections are. And so we're just going to jump in with that. As many of you know, we do have 2 legislators from the Senate, 2 legislators from the House that serve on the commission. The committee's very own Senator Haley has actually been probably the longest serving member on the commission at this point, and we certainly appreciate all of his input and the things that he does to help the commission. Senator McGinn also serves on that. Representatives Barker and Heiberger are from the Senate. Most of those, again, we thankfully, many sentencing commissions throughout the country do not have legislators, and frankly, it is a plus for us to be able to do that, because we can kind of vet some of the policy recommendations we bring to you at the commission level. But you can see here, Secretary of Corrections is also serves on this. We have judges that serve as our chair and vice chair, Court of Appeals, Judge Hill, and then we have representatives from the prosecutors as well as public defender. Probation is represented, Prisoner Review Board. So we really pretty much have everybody from the criminal justice ranks at the table, including a few public members that are, in fact, I'd highlight Jermaine Wilson as one of our public members, who was former mayor of Lansing or Leavenworth, but is still, I think, on the city commission. And so we have a very rich group of folks that are at the top of their field. Some of the things that you may or may not know that the commission does, certainly the impacts that we talk about are important, that you see on a regular basis during the session. And but we're able to actually do those impacts by maintaining databases that allows us to take the data that we have and be able to give the information to you. And so we deal with felonies, not misdemeanors. And so every felony that's committed in the state and sentenced, we have the opportunity to then take the data from a form that's actually in it's a sentencing journal entry. We take that form and then we add the data. We also then, one of our other duties is to maintain a desk reference manual. Most of those are and that's updated on an annual basis based upon what the legislator does here, as well as any type of interpretation that the courts may make during the past year. So we have an operations side, and then we have the Senate Bill 123 side. The operations side consists mainly of the research department, and that's what you normally see with projections and with the impacts. The Senate Bill 123 program, and now the 2020 or the 2021 HB 2026, House Bill 26 program, is a drug abuse treatment program that we spend about $550,000 to $600,000 a month to around 140 different providers, substance abuse treatment providers in your communities to treat offenders that have been convicted of possession or low-level sales or distribution of drugs. One of the other things we do is and that is a major program that we operate. I have a director that is a master's level psychologist that administers that particular program. We also, because and I always give a shameless plug for our office because the data is so good. Our director of research retired recently last April, and he had developed a system in which we have very good data, so we receive private research requests from the coast and everywhere in between on a regular basis. And that is one of our few revenue-generating items that we get. The rest, of course, is we come here every year to ask for SGF funding. One of the other important things that I have in this is my 11th session and 10 years with the commission, and it's very important for us to provide educational training to the practitioners and the stakeholders that we deal with. And so we dedicate a lot of time to education, and thankfully we have our former staff attorney as well as our staff attorney provide legal education, continuing legal education, as well as education to probation officers on a regular basis. We also have a question and answer or Q&A helpline that anyone can actually email the staff attorney. We have judges, attorneys, probation officers that are preparing their cases because the sentencing guidelines are complex web depending on your circumstances. Our office as an agency is a very small agency compared to that of other public safety agencies, but we are a standalone agency that provides objective data to you as well as others, and that's the way it probably should be. Certainly, we are accountable to a lot of folks, but at the same time, we're not beholden to KDOC, KBI, Attorney General's office, that they may nudge us in one direction as far as the data is concerned. So in that respect, it's very good to be a freestanding entity and be able to give you the data as it stands and sits, for that matter. So I kind of will jump through this a little bit as far as the history. The agency is relatively new. The legislature decided in 1988 there was some pretty prison overcrowding litigation that was occurring. They had heard about other states with sentencing guidelines, and so they asked by the Criminal Justice Coordinating Council to establish a sentencing commission to explore perhaps some sentencing guidelines. And so that occurred in 1989. What that commission was seeing in the state was disparity issues based upon race and geography. And if you recall, those of you that are old enough, when we had an indeterminate sentencing scheme, you would get a 5 to 15 sentence. Maybe sometimes you heard that on the radio, the so-and-so got 5 to 15 or 15 to life. There was disparities that actually occurred in rural areas versus metro, and even in a situation where race was involved. There were also proportionality issues as far as different crimes were concerned, and then there was a truth in sentencing aspect in which 15 years necessarily was about a half that, plus I think 1.5 years or something of that nature. So, they set out to actually find a different way to do things, and the sentencing guidelines came about. At that time, Minnesota, Oregon, Washington all had sentencing guidelines acts. Ours is crafted after Oregon's, and what you see and what you received in addition to the handout was this laminated sheet, which we have as far as the sentencing guidelines are concerned. There's a drug and a non-drug grid, just to jog your memory. I will say, just as a matter of course, this is if you have a small plate, it's a great placemat. If you have a large cup, it's a good coaster. So just keep in mind, it's a dual-purpose document. What you see on the grid, at the time that this was promulgated, obviously the war on drugs had just started, and we suspect, can't guarantee, but we suspect that's why we have two grids, a drug grid and a non-drug grid. And you can see in some cases, and that's evolved certainly over the years, but what you see in those are months based upon the severity level of the crime, and then your criminal history. If the chair and I commit the same crime together on the same date at the same time, but I have a larger or more severe criminal history than she is, we have said that I'm going to be punished more severely because I've obviously didn't learn my lesson, and I'm recidivating. And so, the guidelines take into account that. They do it in a simple way. And this was done to try and make sure that all parties involved to the action are going to be able to be involved in the process. So victims could understand that an individual that scored the most severe severity level, which is severity level 1, and then it goes down from there to the less severe. If they were a severity level 1 and they had a criminal history score of E, you know that they're going to get somewhere between 154 to 170 months. And it gives some certainty in sentencing. so that victims can be aware of that, the defendants can be aware of that. Certainly the attorneys and the judge then have some idea at sentencing where the case is going. Certainly things get more complex as multi-count complaints or multiple convictions actually occur, because then you have concurrent sentences that are running together or consecutives that are running one after the other. So hopefully this will actually be, again, a tool. This is the most recent grids for you that during the session you can utilize these. We also sent the desk reference manual for you. It's utilized as I stated before, kind of like the Bible for criminal justice professionals. That is, that's a lot of information for you, and we know that it's your time is very valuable, and so know that it's a resource document that we update on a regular basis. So part of the guidelines themselves, and you see, you have boxes that you're looking at. Those are, the guidelines were set up to reserve incarceration for the most serious offenders. And that is one of the goals with the commission in trying to do what I call the function of the commission, and that is to be the guardians of the guidelines. And we monitor those as well as give you recommendations on how to hopefully make them better as time goes on and as society evolves, and so should the guidelines evolve. Speaking of that last point on the slide talks about primary purposes of prison back then were for incapacitation and punishment. We've moved to not only that, but also one of rehabilitation, in which the DOC has a robust reentry program. When 98% of folks that go into prison are going to be coming out sometime, we have to be prepared to do something with them and teach them a skill. Many of them, as Secretary of Corrections tells you, don't have any vocational training, and that's something that the reentry programs do within the system. So those are the type of things that the guidelines are looking at to potentially the aims that they're trying to assist in. But more importantly, we have presumptive guidelines to allow for equity among offenders in typical cases, whether that be in Barton County or Bourbon County. It also allows for departures in atypical cases. So it does still give discretion to the courts if for some reason there's something outside of the norm for a particular crime. It also allows then for parties to recommend either upward departures or downward departures. What I will tell you is the majority of the departures that are outside of these grid boxes are usually downward departures, and it's by agreement of the party. And so we have very few that are doing upward departures. But in some cases, it does happen, depending on the heinousness of the offense. Those are type of potential departure factors that the court can actually increase the sentence on. The final thing is actually more from a statistical standpoint, and that is it allows for more certainty in predicting prison populations. We could not bring the prison projections to you the way we do right now if we didn't have certainty in sentencing as far as the guidelines are concerned. And an indeterminate structure doesn't allow for the accuracy that you currently enjoy with these. So again, I've already talked about some of the things that we annually do. Again, we're tracking, we track all of the criminal justice bills that come through, and we're doing impacts on those, usually around 90 or so every year. I just wanted to spend just a little bit of time in talking about the impact statements that you receive in your packets on certain bills. Many of the other agencies that you receive give fiscal impacts on how that's going to affect their agencies. We do that to some degree, but our impacts are a little bit different in that they're giving you specific data on hopefully and giving you more information to allow you to make better policy-making decisions. So I'm just going to briefly go over some of the highlights of what you see on the impacts that we give you. If you remember nothing from this part of the presentation, I would ask that you just remember the box. Again, we understand that you have your time is very valuable, no matter where you're at and which committee you're in. So the box actually in the impact allows for specific information on the front page right away at a quick glance, so you can specifically see what kind of admissions impact this is going to be, what kind of potential bed impact that you're going to see. If you want to dig a little further, we do have findings that look something like the slide I have up on the screen right now. But certainly, if you're just wanting to get the synopsis, the box is specifically what you need. And if you want to question any further, certainly then you can go into the findings section. We also have at the end, several years ago when John Rubin was the House Corrections Chair, he had actually suggested that we look at proportionality a little bit closer and do that in a legislative context. You are not considering, and sometimes maybe it seems like, you're considering these bills every single day on a piecemeal basis, in a vacuum possibly. The proportionality comparison, which is at the end of the impact, allows for you to actually look at, for example, if a crime is being increased in penalty, for example, where that actually falls in terms of other crimes, so that you can determine, in this particular example, is a failure to register a third time, that is equivalent to kidnapping as it's being proposed. Is that something that you believe that kidnapping and failing to register for a third time are proportional with one another? So you'll see that in the back of the impacts from time to time based upon those things, and hopefully it's helpful for you. We obviously spend a lot of time trying to put those things together so that you can at least see where does it land in the grand scheme of things. Is attempted murder, is this the same as attempted murder in your view? Again, just a little bit more information for you to hopefully make better policy decisions.
Mr. Schultz, appreciate the presentation. We do have another presentation to get to in the time allotted today, so I just kind of wanted to split it up half and half and leave time for questions. So if we could wrap up with the presentation in about the next 5 or 10 minutes, that leaves just a few minutes for questions. Thank you.
I'd be happy to, Madam Chair. So the annual report, again, you have the handout available, and it goes through, we get a lot of times, what are the top offenses? What are the top 10 offenses? Those type of things. Well, you can kind of give, and why do we do this? The main reason, obviously, is that hopefully at some point you will see some recurring themes here with some of the crimes, either those that are in your jurisdiction or statewide. In particular, in this particular slide, we see that drugs occupy a high percentage of the prison, probation, and jail sentences. If we see this enough happening, at some point we obviously need to perhaps turn our attention to drugs and see what we can do in solving those problems. You can see that there's other crimes, violent crimes, criminal threat, aggravated battery, burglaries also occupy that top 5. Just to give you an idea of the demographic information that we possess, we do have race and gender distributions and ethnicity and age distributions that are available for essentially every crime, so that we know those things. We can break things down into prison sentences as well as probation sentences, and you have those in your materials as well. COVID obviously has decreased the amount of admissions that have actually occurred to the prison system, And so that has affected certainly the system as a whole. I'll talk about that in just a little bit, but just to kind of give you an idea, again, your drug sentences, normally 8 out of every 10 probation sentences are those for possessions, because mainly most of our felony crimes are on the drug side or possessions. We also look at the top 4 counties as kind of a guide for us as far as the largest counties. Sedgwick, Johnson, Wyandotte, and Shawnee normally have about half of the felony offenses. Sedgwick County, for every 5, Sedgwick County has one of those, basically 20% of all crimes in the state that are felonies. The population projections, I'm going to touch on this just a little bit. As you can see, the last 2 years, our prison population is down. In fact, as of, I think, several days ago, it was almost down 2,000 inmates. And while that's great, and that's a good thing, because it takes pressure off of the staff and DOC and the facilities in general, it certainly has not been a magic bullet. As you can see, we have admissions versus releases. The releases have actually are ahead of admissions, and that's why we have less folks coming into the system. Just jumping through here a little bit, our probation violators are down as well. The admission trends for prison are down as well. So this is the main takeaway as far as the projections. Again, we do 10-year projections for KDOC. The normal items on the right-hand column are normally always positive. Almost every single one of them, except for I think the levels 7 through 10s are negative. And that's basically based upon the lack of admissions to prison. So our 10-year forecast at this point is we're projected to be down 4.5% in the next 10 years. Keep in mind that, again, I will have make that a caveat, and probably Mark coming on next can probably give you a better idea of that as well. We do have a backlog in the jails, and a lot of those, or possibly even the majority of those, are more severe offenses that are going to be doing more time in prison. And so those folks will be making their way through, and they will be admitted to prison for longer than the 2-year average that we normally have for folks. So bear in mind that while this looks great and that we are down 2,000 on the men and women side together, that the tsunami is coming, and we are anticipating that. For forecasting purposes, we can't do that because we basically have a look-back period that we utilize. So we understand that there is more opportunities at this point because we have fewer folks in prison, but at the same time, those others are going to make their way through. That should be something, and I would encourage you to be thinking about that due to the staffing shortage with DOC, they have closed 12 housing units. So essentially, the amount of beds that have been taken offline, we are basically at capacity because they can't staff the rest of the facilities to be able to hold more people. So in essence, we actually are at capacity. So I would encourage you in going through the process this session to be looking at those sentencing reform efforts similarly that you did pre-pandemic, because we are, the staffing shortage is not going to be solved anytime soon. The rest of the information is you can look at in your package. It's simply kind of gives you a visual of what that what the prison population projection looks like and where it was prior to that. But that would be the extent of my remarks, and would be happy to stand for any questions. And again, I would ask, Madam Chair, and I apologize, again, if you have bills that you want to pre-file, if you have any other information and want data from us, please email me, please call me. We are always happy to, if you're wanting specific information on specific crimes, we're happy to do that work and get those things to you.
Thank you, Mr. Schultz, for that very thorough and informative report and presentation. I do have to take exception with one thing you said, though, that you and I had committed any crime together, or that I had committed any such act, but I know it was just used for example purposes. But questions then? Yes, Senator Haley, we have just a few minutes.
Not even that long. I'll take, Madam Chair, and thank you for your forbearance. I just wanted to commend the Sentencing Commission, and by the way, dovetailing into our next presentation, Mr. Schultz does serve, I think, as an officio or ex officio member on the Criminal Justice Reform Commission. So being a part of this process, and by the way, today I learned more that I hadn't known, even though I've sat on, as you've said, the Sentencing Commission. I always appreciate this. To the members of our committee, Mr. Schultz is a tremendous resource when we want to look at the projections. Will we have to build more prisons, which is always a question that comes before us. Do we want to have that? Mr. Schultz and the Kansas Sentencing Commission has been a tremendous resource in evaluating the crime meeting the time, or the time meeting the crime, whichever the case may be. You spoke toward proportionality. They're almost unerring. I don't know what your percentage rate has been in the projections. You could tell us previously. And it's a snapshot of what we as a society in Kansas will do within our criminal justice system, and with the implementation of it, if we look at these projections and the data that they compile so unerringly. And for me, it's always a learning experience, and I appreciate, again, the time that you take and that your team takes to bring a stellar effort on a national basis, especially since we implemented Senate Bill 123. We were the initial state to do that. And I just wanted to lift that up because I'm exceptionally proud of Mr. Schultz and our commission. Thank you, Madam Chair.
Thank you. Other questions? I have two questions. I think when you refer to tsunami, is that because we've had a backlog of criminal jury trials, and then once those start going again, there will be what you would refer to as tsunami? Is that what you were talking about?
Madam Chair, that would be correct. We do not, when we do projections, we're looking at admissions to prison, and so the jails, my understanding, are fairly full, and those are normally pretrial folks that have not gotten through that process yet of having their day in court. And so, yes, that would be correct.
Thank you. And then one question about one of your graphs. The pages aren't numbered in the presentation, but it's in the annual report section, the 4-county felony sentencing trends. And there was a chart there that showed, I think, the 4 most populous Kansas counties and then other counties combined. Could you explain that? Could you explain that just a little bit more if I missed it? Does that mean other counties?
Others are the rest of the counties. We just look at the big 4 because normally that's where half the felonies are actually committed.
So is this the percentage of, so Sedgwick County has 19.6% of, what is 19.6% of the felony sentences in the state, or what is that?
That would be correct, Madam Chair.
Okay. And then, all right, so, and has the commission determined why Sedgwick County is the single largest sentencing county for felons?
I think that's probably because of their DA. No, I'm just kidding. No, that's normally it has always been, it's the most, populous county, and therefore, this has been the trend for many, many years as far as the percentage, and it fluctuates by tenths. But normally, Sedgwick County is always leads with in terms of overall sentences.
Does that mean Sedgwick County has the most felony crimes committed, or do we know that statistic?
That would be, I can't answer that question. I can tell you the overall sentences themselves. as far as the crime itself, that would, I can't tell, we don't have those numbers.
Is that something you can look at, or if, if we have one county
The only.
more crime-ridden than others, we want to be able to look at that?
Correct. The only information that we actually are able to receive or what's actually received from the sentencing journal entries. At this time, I know that OJA may have that data as far as the amount of complaints that are filed and those type of things. I'm sure that the DA's offices, KCDA, probably maintains some of that information as well. And how that conversion occurs, I don't know. We are on the back end in terms of being able to know what the individuals were sentenced for, not necessarily what they were charged with. We know what the plea was, but not what the sum of that. KBI also has arrest data that is available too.
Thank you. Committee, other questions? Seeing none, then, thank you, Mr. Schultz, for the very thorough presentation and the laminated copy that we have that will come in very handy, I think, for committee members and the report. Appreciate it. We will now turn back to our other presentation today from the Kansas Criminal Justice Reform Commission. Do we have the conferee Mark Bennett on WebEx? We do. Okay, well, great. Well, if you please introduce yourself and welcome to committee.
Thank you, Senator. I apologize. I was in the waiting room in WebEx and I'm not sure what I did, but sat there and didn't get plugged over. So sorry to keep you waiting. Mark Bennett, District Attorney in Sedgwick County, also the chair of the Criminal Justice Reform Commission. I want to thank Chairwoman Warren and other members of the Senate Judiciary for giving me this chance to talk. I'm going to give you a brief overview of the highlights from the Criminal Justice Reform Commission. I'll jump right into it. Obviously, the commission worked for 3 years on this issue, and we've left the legislature with some 21 recommendations. Obviously, too much to do in 1 year, but the idea is it's a template for years moving forward. Among the recommendations, I'll just go through them quickly. A pre-filing diversion opportunity. Right now, the law is pretty clear that you're not supposed to, as a prosecutor, agree to pre-filed diversions, meaning I agree not to file this case on a diversion, it'll never be filed. There's any number of reasons for that, public policy reasons, not the least of which is I think we want to do things above board and in open, openly, so that the public can know who's getting these diversions under what terms. In a pre-filed diversion, there's really no accounting for it, no accountability for it. And so that would have to be worked out, but that's one recommendation. Number two, and I would say this one, number two, is one that if I was to prioritize, I would suggest some priority be given to this, and that is consolidation of supervision. People placed on probation, they might commit a crime in Butler County and also commit a crime in Wichita and Sedgwick County, and maybe granted probation in both counties. And so now they are answering to two separate probation officers, which could be cumbersome and essentially redundant in many respects, not the least of which is meetings they have to have with the PO and maybe even fines and fees. And so the notion of consolidating supervision to make it more efficient and eliminate the duplication of resources and fees is something that we think could be very beneficial to the state. I would not have known this had not been for work at the subcommittee for the Justice Reform Commission, but some 1,500 to 3,600 people at any given time in the state of Kansas are on probation in more than one agency. So it gives you a sense of the scope of this issue. Number three, standards for communication in dual supervision cases, and up to and including suggestions or even implementing laws regarding how often they should schedule team meetings, that sort of thing, when people are on supervision in multiple jurisdictions. Number four, proportionality of penalties. I think Scott just went through quite a bit of that, but the notion specifically that we recommended was some consideration be given at least to decreasing drug level 5 possession felonies, the time at least, the underlying penalties, to something more equivalent to what would be called a level 8 on the non-drug grid. And there are a couple of Senate bills from 2019 and 2021 which had given effect to that, so we'd refer you back to those. It's set forth in the written testimony here. Number five, felony loss thresholds. When someone takes money, commits a property crime, many times the point at which it becomes a felony is not the nature of the crime, but the amount taken. And it's a little bit, we haven't done a particularly great job of keeping them consistent. There are, I believe, 11 statutes which need to be addressed. In some statutes, it's $1,000 for the felony threshold, and others it's $1,500. And we think that should be consistent across the board at $1,500. Again, it would raise the threshold up. There'd probably be fewer felonies in some regard, but needs to be consistent. Number 6, DV convictions, priors, and how they're counted. A prior DV, domestic violence conviction for domestic violence battery, after several, on the third one of those, you can become a felony. The state legislature, though, also several years ago passed a DV tag legislation, which means even something that's not a domestic violence battery, he doesn't put his hands on her necessarily, but he may, the suspect may have committed some other crime, which was a domestic violence motivated crime, and that has been found by a judge, etc. That does not trigger the prior finding then. So when he goes out and does finally batter the victim, those others don't actually count toward the raising of the penalty there. And again, it's not going to help in terms of bed space, but we do think it's a public policy, public safety issue that deserves attention. Number 7, drug and non-grid sentencing grid amendments. Amend the drug and non-grid by expanding the presumptive probation and border box zones. There's a lot to unpack there, but there are 2 bills, one from 2020 and one from 2021, which address that. I put those in the written testimony here, and I think it at least deserves some attention. Again, those bills were introduced in the past and were likely to be introduced again, but it's something worth discussing. Number 8, compassionate release, just expanding the compassionate release programs for inmates in the Department of Corrections. These are folks typically on the end of their, well, maybe not the end of their sentences, but into their lives, and they may be in some, hospice, that sort of thing. And to be very blunt about it, it's probably also a tremendous cost savings to the DOC, not to have these folks in their infirmaries rather, but it's a compassionate release issue, and it was raised and thought it deserved to be included in this. There have been, again, 2 bills in the past, one in 2020, one in 2021, which sought this or detailed this, and would refer the committee back to those. Number 9, sentencing grid consolidation, combining the drug and non-drug sentencing grids instead of utilizing separate grids. I will say that we recognized as we can discuss this that we were not of one mind about that on the commission. Not everybody who represented an entity on the commission would agree with that. However, we all agreed that it is time for that discussion. It needs a proper vetting, and it probably deserves a hearing, or at the very least, giving it to a subcommittee at some point to address it even further. But there are proponents and there are certain opponents, but it is an issue that I think deserves the legislature's attention. Number 10, CORA, and I don't mean open records, I'm talking about Kansas Offender Registration Act, the penalties, decreasing the penalty. I think I got on here, obviously after Scott had started, I think he may have mentioned this, but decreasing the penalty for noncompliance with the Kansas Offender Registration Act. There's a lot of room there's a lot to be discussed there. There's a lot of ways to handle that, but not everybody who violates the Registration Act is probably of the same ilk, and there may be ways for graduated sanctions for addressing this and making and reducing the penalty for folks that wouldn't necessarily pose a tremendous safety risk. There's even a philosophical question that the policymakers and the legislature probably need to address, and that is, do we really need to have drug offenders on a registry? This started off as a sex offender registry. We expanded it to a violent offender registry, which I understand. The drug offender registry, is that public policy that in somehow is enhancing the safety of the state? I think that's a question that needs to be addressed. So that's another angle to this as well. Number 11, an exit mechanism for certain registered offenders. There is no real exit mechanism. Once you're on the registry, you're on the registry. Now, I would be careful about saying, sure, you can file a pleading with the court and ask for another hearing. Our dockets are chocked full enough as it is to add another avenue for someone to come back and have a hearing every month they get tired of going down and registering, I think would be the wrong move. But there may be some mechanism by which We want to consider an off-ramp for folks who have been on the registry but have been successful on their probation or done their time. They have been successful on parole, haven't committed new crimes. Is there some reason or some mechanism to let them out or out from underneath the registry? Number 12, also kind of in the same theme of the registry and online offender registry search. Some of the folks were on the committee wanted to make it clear, if you go on the registry right now and look up a registered offender, is somebody on the registry, you'll get everything, sex offenders, drug offenders, violent offenders. And I think there are folks who think that's probably not as narrowly tailored as it ought to be, and maybe should be a more tailored website. And so there's whether that requires legislation or not, I don't know, but certainly it was raised, and we wanted to bring it to the legislature's attention. Co-responder, number 13. This is something that I think is, if I was going to give attention, if I was one of the chairs of one of the subcommittees, this is something that I think could, it's not a one-year deal. This is probably going to take some time, but it could be the first, it could really be something that could change the tenor and tone of law enforcement and the criminal justice system in Kansas on a pretty large scale, and that is co-responder programs. It's Topeka has one, Wichita has one, ICT one, which indicates we have literally for the entire city one team. But when a mental health call comes out, sometimes we don't know that it's a mental health call when cops respond, but many times they do. And so who gets sent out when there's somebody who's in some mental health crisis? A cop with a badge and a gun, and it does not always go well. And sadly, officer involved shooting cases, deaths in custody are almost, well, in my experience in Sedgwick County, almost all have had either a component of acute drug use in the moment, or, and this is far more likely, a mental health issue that the person is encountering. And the point is to instead on these co-responder programs to maybe send a cop to make sure people are safe, kind of stand back, but the person to go out and interact is a trained clinician, somebody with mental health background, not a cop. And where it's been employed, it's been wildly successful. The question is how to expand it across the state. We need standardization. What's going on in Wichita should not look markedly different than what's going on in Dodge City or elsewhere. But there's going to need to be a standardization of this. There's going to need to be, frankly, a mechanism for training and funding of these sort of things, and frankly finding the right people, because around the rural parts of the state they don't have access to clinicians just on a one-on-one basis. If you wanted to go retain somebody, go to the doctor or go to the psychologist, they don't have enough of them, even in that environment, to find somebody who's going to work 24-hour shifts or work a third shift with that kind of background is going to be very difficult. So what if anything is the state willing to do en masse to expand the use of these programs? So I've spent more time talking about that than any of the other recommendations thus far, but I think it is that important. Number 14, training. I think this is something that you hear in a lot of these discussions about criminal justice reform, and that is better and enhanced training, not only for law enforcement, but for probation officers, parole officers, licensed mental health providers, etc. There's a litany of examples set forth here. I'm mindful of the time, so I'm going fast. You can see it set forth there. 15, CPOST membership, expand the CPOST membership to enhance its diversity. 16, this would be a simple fix. The gangs, criminal street gang statutes right now say that if you're listed as being a criminal street gang member, your bond must be at least $50,000. We believe it could simply be changed to say appropriately set. The bottom line is if I have a gang member who shot at somebody, 50 grand is not probably enough, and I'll ask for a higher bond. The gang member did a flee and elude where he ran from the cops, $50,000 may not be appropriate. I trust that if we have somebody who's a threat to society because of his or her involvement in a gang, we're in a position to let the judge know that, and the judge can set an appropriate bond. I think setting an arbitrary $50,000 made sense in the late 90s when the bill was passed. I don't think it makes sense today. And the kind of coming around the home stretch here, number 17, criminal street gang definitions, reevaluate the definitions related to street gangs, and set forth in current statute 216313. And then finally, the last four, number 18, incentives for early release and discharge from probation, parole, etc. to include both misdemeanor and felony offenses and discuss those issues. 19, behavior management system. There was a group that suggests that we, as a state, engage in a more particularized behavior management system. Number 20, sanctions and incentive structure. Encourage DOC and OJA to collaborate on a sanctions and incentive structure to be used within the criminal justice system. Again, in terms of what are the incentives for probation? How do you get off of probation? How are you successful? And what are the sanctions when you're not? Let's be consistent about that. And then finally, 21, standardized terms and conditions of probation. Again, there will always be regional differences. What I expect you to do in Wichita may be different because of your access to available services here. We may have more clinicians. We may have other services that they don't have in Pratt or in Goodland. But the core response, what does it take to be a successful probationer? It should not look markedly different from Pittsburgh to Goodland, from Kansas City to Liberal. I mean, we should all have a core group of 10 or 15 things that we expect people to do. And our study through the commission found that was not always the case. There are marked and sometimes unexplainable differences. I think it's just sort of some mission creep over the years. We do it this way because we do it this way. And I think it's time to clarify that. And that's another one of those things that's in that top 5 or so of my recommendations to you. 21's a lot to digest, but if I were you, that'd be one that I would want to address. So I spoke fast. I apologize. I see it's 11:28. Didn't leave a lot of time for questions, but I wanted to get this in front of this body. And again, I apologize for being late to the party. IT is not my specialty, but I was proud of myself for being in the waiting room and realized I was all alone. So thanks for your attention here.
Thank you, Mr. Bennett. Technology has its challenges sometimes, for sure. Thank you to our IT department for helping us out each and every day on that. So appreciate that. The committee questions. Yes, Senator Gossage.
Thank you so much for that explanation. I had a question about parole, and I didn't see anything in there. How are we doing as far as helping people that maybe have paid their debt to society, maybe they're ready to go back out, and we're talking about overcrowding in our prisons. How are we doing with that?
Well, you're talking about a couple of different things here. Parole is once the decision's been made to let somebody out, and how do we incentivize, or how do we make it more efficient, more productive, and lessen the likelihood that they would go back into the penitentiary system. Some of the things here do actually address that. Incentivized release, incentives for early discharge and that sort of thing. Having a standardized group. If you do these things, if you do these core things, we could give the parole officers the discretion to release somebody early, that sort of thing. And so once they're out, there's a lot here to help folks, or at least to help the people that help folks. The behavior management system, some of these other things that are discussed in 18, 19, 20, 21 less so, but they're in there. It's kind of baked into this report. On the other end of what you said, you're talking about getting people out of the penitentiary and trying to alleviate overcrowding. That's a little different than parole. That's more of the things that Scott Schultz was talking about. That's also some of the things that I've talked about here when I'm talking about proportionality of penalties. Felony loss thresholds, things like that, having fewer people come into the front end. But in terms of letting someone out early, the only thing that really, the only accommodation for that is good time credit. We didn't really get into that in this. We got 20% for lower level crimes, 15% for higher level crimes. And we don't address that here. But that's where the law sits today. And the DOC really does not have the discretion. When a judge says you're going to do 10 years, you're going to do 10 years unless you behave well, and then you'll do 85% of that, or 20 or 80% of that, depending on the level of your crime. That's probably the best answer I can give you.
Thank you.
I have a follow-up question to that, Mr. Bennett. Hearing recently in the news about parolees and crime, is there a correlation happening there, particularly in Wichita, or could you expand upon that?
Sure. There's, well, first of all, understand that when parolees come out of the penitentiary system, the KDOC, several times, many of them go to what's called the work release program. And if you're a female I believe that program is located in Shawnee County in Topeka. The male program, and unless I'm mistaken, the only male program is in Wichita. If you're familiar with Intrust Bank Arena, it's literally to the southwest corner, catty corner from the Intrust Bank Arena downtown. I believe, and again, unless something's changed in the last 6-8 months, that's the only such facility in the state of Kansas for male offenders. Wichita Police Department believes that the influx of those folks in the Sedgwick County, whether they're from here originally or not, may be a contributing factor to driving crime down here. There's been some studying of that effect, or of that by, I believe, Center for State Courts or state government, excuse me, which looked at it and didn't find maybe quite the same one-to-one correlation, but there is no doubt that folks are coming here, whether they are from Wichita or not, whether their support system is in Wichita or not, and whether that is what drives crime or not. I still think, when you go back maybe to the earlier question about helping people who paid their debt to society, would it be better if you're from Garden City or Dodge or from Lawrence or Leavenworth, when you get out of the penitentiary, to be sent first to Wichita? I mean, there's a philosophical argument there. If you did poorly and you got in trouble in Leavenworth the first time, maybe going right back there isn't the best thing for you. However, whatever support system you might have, whatever that may be, good or ill, isn't in Wichita. And does it make sense that that's the only place for males? I would suggest that at some point as a state, we're going to need to adequately fund KDOC so they can open up more of these work release facilities around the state for men, so that when they do want to go, when they get out and they've done their time, that they are better able to transition to their home communities where support structure might be.
Well, that was going to be my next question. Is there something the legislature can do? Are we looking at a bill that might help alleviate the problem in Wichita? Or I've heard conflicting information that the parolees there don't commit crime at a higher rate than the general population of Wichita. So is this something the legislature can help out on and take a look at?
Yeah, so on that point first, I'd say at a higher rate, maybe not, but they're still here and committing crime. And if they were home, they'd be committing it somewhere else, I suppose. So it's a bit of a double-edged answer there. But to your point, can the legislature do something? I'll defer to Jeff Zamuda in this respect. Yes, you can do something, whether it needs to be a bill. I'm not aware of a state statute that requires the DOC to only have one work release center in Wichita in the first place. So it's not as if there's a law that he's following that he's constrained from opening up another one in Lawrence or in Kansas City or in Dodge. But it may be a matter of funding. It may be a matter of implementation of resources that already exist. But whatever he would need to do that, to have more satellite work release offices around the state, I'd certainly be in favor of that, and I would think that would be beneficial to the parolees, and it would be beneficial to their families to have them closer, and hopefully it would be beneficial to recidivism rates and reducing the likelihood these folks would get back into trouble again.
Thank you. Committee, other questions? Senator Haley.
Thank you, Madam Chair, and thank you, Chairman Bennett. Incredible amount of time I just want to share with the other members of our committee has gone into it from a cross-section of stakeholders. I mean, from all over. If you look at the members that we have, not only myself and Senator Wilborn, but also non-legislative members. And Chair Bennett, the time that's gone during the interim into going over some of the recommendations that are before you now have not always been easily reached. And he and Vice Chair Representative Owens shepherded us through this, through the committee and subcommittee process to a couple of questions that just came up. Some of the conditions for supervision are on, I see, page 8 of the final report that we gave. It went through because recidivism is a huge concern when we look at reform and how we can, what we can do to abate those and to make those terms less onerous, as was referenced previously in Mr. Schultz's discussion. We don't want to look at somebody who's going to recidivate or be equally culpable of a much greater amount of time by a policy that just doesn't make sense. We've had people go back, for example, for we call it dirty urine. I forgot the acronym for it, but they failed a drug test while they were out on parole, and they go back and spend more time than sometimes someone of a much more heinous crime would do. So I just wanted to commend Chair Bennett as a member of this committee and many others who spent so much time looking at these recommendations. I'm looking forward to the bill introductions that will be, I think they're starting on the House side, and say that they have been poured over by a cross-section, various philosophies that have come to play. And finally, it was mentioned in our report, you know, the genesis of this came from Russ Jennings, late Representative Russ Jennings, and also it was coordinated and brought into play by Reggie Robinson. So this has been, we're a link, if you will. We're just the latest incarnation of a lot of people who want to look at and hopefully better our system so that we don't waste time in people's lives who would not recidivate and who may not have even, in some cases, be charged in the first place if we have a more equitable system. And thank you, Madam Chair. And thank you, Mr. Bennett, Chair Bennett, for all of the work that you've put in.
Thanks.
Thank you. Committee, other questions? Seeing none, then thank you very much, Mr. Bennett, for the thorough report and the work of the commission. We appreciate that, and we'll look at if there are any bills introduced or sent over from the House. Something to keep in mind. Yes, sir. Mr. Bennett.
Last thing I listened as Scott was finishing up, and I know I'm over my time. I'll make this very quick, just to give you a sense of jury trials and backlogs and things, because it's not part of the Justice Reform Commission, but you were asking. We've got 153 pending homicides. 121 of those are active. Others are on that warrant status, etc. 16 have pled in the last few months. We had 51 jury trials between May and December of last year when things began to open back up. Of those, 19 were called off-grids, so murders, Jessica's Law, etc., and another 60 off-grids pled. So to be very blunt, a hell of a lot of work is getting done down here, but we still do have a backlog and a lot of cases to work through because of the shutdown that occurred in 2020. But, that's a lot of cases that we're moving. So just wanted you to know that.
Great. Yeah, I appreciate you bringing that up. Actually, we did spend a lot of time in committee last session looking at statutory speedy trial and hearing from the judicial branch about getting jury trials up and running. Are you finding that that process is operating more smoothly in Sedgwick County? I guess you gave us a report from May through December. Is that continuing? Jury trials are occurring?
Yeah, we're 10 courtrooms for criminal jury trials are open every day. I don't see us shutting down ever again, frankly, absent some, I don't know how bad it would have to get before we'd shut down again. I would say too that the speedy trial the statutory speedy trial being stayed has also helped because we are not having people clog up the courts with motions to dismiss based upon that. And instead we're getting work done. So the minute the courts opened up again and cases started flowing, I think that's when people started recognizing that, it's time to start getting down to brass tacks. We're going to try this. We're going to work it out. The only downside is, as Scott mentioned, those that are left, frankly, many of them are more serious crimes. I've got 12 or 13 murder cases myself personally right now. And, those are tough cases to work out. And, you want to plead to 40 years, really? That's not a conversation most defense attorneys have much luck with. So the cases that are going and are being tried are largely very serious with heavy sentences in play.
Thank you. And committee then, with that, we will adjourn. Thank you very much.